This video is going to build on the last video by giving a little more background into what's going on in natural law theory, but the purpose of this video is to focus on a critique that comes from the philosopher David Hume and others, which is going to claim that the basic approach of natural law theorists is basically wrong. That critique almost killed natural law theory until the 20th century, and it was only in response to a series of developments in the 20th century and the thought of a couple of important legal philosophers, Longfellow and John Finnis in particular, that saved natural law theory and allowed it to come into the 21st century, actually being taken seriously as a theory of law. So recall that natural law theory is based on the idea that we can observe the natural world and draw legal principles from it. Okay, however we do that, that's the idea. We are rational beings, and rationally we look at the world, which itself has a rational structure, and we draw from it the kinds of principles that are going to be useful in constructing institutions, political institutions, and just legal systems. Okay, just by which I mean characterized by justice. Now, some philosophers got the basis for this from philosophers like Plato. Plato, you'll recall, had his theory of forms. The theory of forms has it that any particular object in the world has its characteristics because of their participation, or because of the object's participation in values or characteristics or principles or so on that exist independently of the object. So an object is hot because it participates in warmth, and an object is beautiful because it participates in the form of beauty. The beauty of an object isn't due to the object itself. It's due to the participation of that object in the ultimate form of beauty, which is reflected, however well or poorly, in the object itself. So a beautiful person, a beautiful work of art, and a beautiful sunset are all beautiful because they are characterized by participation in the ultimate form of beauty. And you've seen this in your previous classes. Now, this is also true for ideas like goodness. Something is considered good because it draws upon the value of goodness that exists independently of it. And so we have an objective standard by which we can determine if things are good. That's also going to turn out to be true of the value of justice. A law will be just if it draws upon an ultimate value of justice that exists independently of any given law. So now, that's Plato, and you can see how that kind of an idea can then get reflected in a view of natural law, where you're going to try to figure out why a particular law is just, or whether it's just, and you're going to do it by comparing it to an absolute standard. Where does that standard come from? Well, Plato has his idea. Aristotle, now the disciple of Plato, he said that, to take the example of justice as the best example, a law is just because it originates from a just source. The just source should be a just human being. Human nature being what it is, we can observe human nature in order to determine what's good or bad for people. So if we talk about the common good, for example, from an Aristotelian point of view, we're going to analyze human nature. We're going to work out what is rationally the best for humans, and then we're going to objectively be able to create laws that reflect that. And that could include observations, again, of the natural world around us, the way animals relate to each other, the way trees and rocks operate in the natural world, the processes of growth and decay, reproduction, death, and so on. Now, here's the thing. Aquinas and other natural law theorists in his period, up to the period of David Hume, who's the person I'm going to be talking about now, took as a basic assumption that we could look at the world around us, rationally evaluate it, and then draw from the world principles of natural law, which could then be turned into principles of human law simply by using our rational faculties. In other words, we look around the world, at the world, and we see how the world is, and from that we determine how we ought to behave in that world. Seems relatively straightforward until you get to Hume. And Hume asks us this question. He says, how is it possible for us to observe the way the world is and get from that the way we should or ought to behave? How are we able to look at the world around us, which is objectively observable, and get from that moral or other values that ought to be applied in our own lives or in our own communities? In other words, you can take this syllogism from Hume and you can ask this question that I just posed based upon this syllogism. The syllogism goes like this. All animals procreate. All human beings are animals. Therefore, human beings ought to procreate. Now, if we had said, therefore human beings procreate, that would have been different. But what we said was, therefore all human beings ought to procreate. And the question is, where did this ought to come from? Hume says, this ought cannot legitimately be derived from that is. Hume's principle, in other words, some people call it Hume's law, is you cannot derive an ought, a statement about how we should or should not behave, what should we or should we not do, what is morally right or wrong, and so on. You cannot derive an ought from an is. This is a very elementary sounding idea that actually pretty much shook the foundations of natural law theory. I'm going to give you a couple of terms here. All right, we're talking about Hume's principle, which is moral duties are not to be derived or cannot be derived from statements of fact. That's Hume's principle. Moral duties cannot be derived from statements of fact. It seems obvious, at least at a certain level. This is connected to the notion or the theory of non-cognitivism. Non-cognitivism is the idea that moral values are not objectively true or false. If I make a moral statement, if I make a moral claim, I'm not making a claim about things that are true or false. In fact, my statement itself cannot be true and cannot be false. So if I say X is good, if I say that education is a good thing, then I'm saying something that is neither true nor false, objectively speaking. I'm expressing an opinion, I'm declaring an emotional state, I'm telling you what my preferences are, I'm saying what I think would produce a happier life, but I am not making an objectively true moral statement. That's moral non-cognitivism. That's the contrary to another view that slight differences here, but the contrary to that is moral realism. Moral realism is the view that moral statements can, in fact, be true or false. So when I say education is good, you could argue with me and we could have a reasoned discussion about whether it is good and our moral claims would be true or false. That's moral realism. According to a moral realism, if you make a moral judgment, your moral judgment is either right or wrong. But Hume is coming along and saying, obviously, he's taking the side of the non-cognitivists, and he's saying that moral judgments, at least, cannot be drawn from objective statements of fact. And in fact, he'll actually claim that they are expressions of desire, expressions of emotion, expressions of preference. Just to bring this out, this is slightly different, but connected to what G.E. Moore, famous 20th century philosopher, called the naturalistic fallacy. The naturalistic fallacy is the fallacy of saying that goodness or badness is a natural quality of a thing. In other words, it's saying that the thing that Aristotle said, that we can draw goodness or badness from from the nature of things and say that it's a quality of the thing, the view that Aquinas held, the view that in fact Plato held, and others like that, Moore is going to say that's just wrong. Goodness or badness are not natural qualities of things. They are imposed upon things from the outside by us as expressions, again, of our preferences, our desires, our judgments of what would be practically good or bad, etc. So when we think about the objection brought by Hume and the challenge of non-cognitivism to natural law theory, it's actually relatively straightforward to start saying, well, natural law theory is just based on a faulty assumption. It's based on this bad assumption that you can derive an ought from an is, and that's the end of it. So we cannot talk about moral values just based upon the things in the world.
But wait, we think that human rights are important even if they contradict what's in the law. Does Hume's law mean that human rights are really just opinions?
Well, thank you very much for that question, person who's not in my class. You're absolutely right. That's the problem. In the 20th century, we encountered some atrocities that caused us to start thinking differently. The textbook mentions a couple of these. It mentions, for example, and very importantly, the Holocaust. If you think about the Holocaust, the Nazi death camps, and then think about similar events throughout the 20th century, especially up until, well, never mind, just throughout the 20th century and even into the present day, we still have these kinds of atrocities going on. This seems to be the kind of thing where I can look at the events that are happening and I need to be able to say, those are just bad, those are wrong and evil and they should not happen. We've identified this category of evil called a crime against humanity, and we think that it's a real thing, even if it was a perfectly legal thing to do in the time and place when it occurred. Let's not forget that Auschwitz was legal and in fact encouraged by the law of Nazi Germany. Similarly, the whole notion of a human right, before we put them into charters and bills of rights, human rights actually are considered to be actually existing principles which impose themselves upon us and upon our structures of law in such a way that if a law violates an important human right, that law is not just, not fair, not right, and must be overthrown. If that's the case, if in fact laws are subject to this higher law of human rights, then where are we getting that? We seem to be getting it from an observation of evil in the world, and we seem to be going directly from an is to an ought. These evils occurred, they must not occur. They are wrong. We must stop them from occurring. Any law that violates human rights is an invalid law. Any law that causes or permits a crime against humanity is an invalid law. These things must not be permitted, and we base that strictly upon our observation of these things occurring. But we need to find a way around those questions because those questions are very important. There are various ways to do it, and one of those is the way that was proposed by John Finnis in his important book, Natural Law, Natural Rights, and it was also proposed by others. And so in the next video, we're going to be talking about Finnis in particular and his response to that problem. So, see you next time.